Setup preempted two arguments. On setup, what is our model? This is quite, there's a lot here. Firstly, what I want to note is that the jurisdiction of this court is in all places within the South Pacific, and what that means is the judgments that this final court, that is of a higher tier, makes, is binding on all lower courts within its jurisdiction. Second of all, when interpreting its laws, is with reference to the legislation in the statute in the specific country or the jurisdiction where the legal action is taking place. For example, if it is a trade offense, it's happening in that country and it's with reference to the trade regulations of that country. Thirdly, we would allow virtual hearings in these causes and not force these people to fly over to these countries. We already allow this in many places. For example, for my CCP law report, I had to go to the Waverley local court, and we allow defendants to zoom in over Skype, which explains why that's perfectly normal. We would allow that, no harm to accessibility. Fourthly, this is crucial. How would this judge be elected? We're going to have a similar very system to the ICC because it is quite a well-appointed system. How does this work? Firstly, we're going to have a rotating panel where each person has a term limit of 9 years, and we'll change the panel after that. Secondly, in terms of the election process, each country within the South Pacific would be able to put forward its own judge, a series, 2 to 3 candidates who they think are worthy for the job, and they would be elected there. Thirdly, there will be no country with veto power, so it's the majority vote that would do that. So there's no single overwhelming power doing this in the court case. And fourthly, we would model in a rigorous pre-selection process. In these countries, oftentimes this isn't the case. You have to rigorously assess the ties to corporations and companies that these countries have, that these people have, ensuring that they are making the right decisions in the right cases. And what I would note is that because of this model, even if there's one country that's a bad actor, the overwhelming influence of many other countries that aren't bad actor crowds out that bad actor. Which is why, despite the fact that in the UN, the US and Israel have overwhelming amounts of power, in the ICC, there's rulings made in very good fashions. But in this case, it wouldn't be all bark, no bite. There's bark as well as bite. Fifthly, what types of cases do these courts hear? We would note that it would be cases such as cases of public leave to appeal. What that legal jargon is for. It's just that if there is a case with significant amount of public notoriety or public standing or is important, that is justification and grounds for that being case heard. Whether it be a case on abortion rights, on crackdowns or freedom of speech legislation that these governments have implemented in these cases. Or other courts, these courts can also decide, they have their own tribunals which decide whether or not these courts own cases and work well understanding. That should pretty preempt any claims about accessibility, any claims about these decisions being made very badly. This is a pretty good model. Cool. I want to preempt their claim about sovereignty or principal infringement on sovereignty. 4 responses. Firstly, what we know is that oftentimes courts in their rulings are drawn from jurisprudence in cases in other countries. For example, seminal cases such as Donahue and Stevenson or Jade, Bennett and Kwak. Those cases are cases that were decided in the UK, but because those are historic cases, they refer to them and those justices and their reasoning to be used because a lot of their stuff like battery, assault, treason is transferable across many jurisdictions. Second of all, this right to representation doesn't extend to courts that much, they're elected in very technocratic ways, because we view the court as an important balancing measure on the public selection of the legislature, which is why we're perfectly fine with that encouragement there. We have technocratic detailed process doing that there. But thirdly, we would note that oftentimes, specifically South Pacific countries are already signatories to international claims and treaties, such as climate change agreements, and they deferred a lot of their rights there. Explaining that these countries are totally fine with deferring a lot of their rights, or this principled infringement isn't that important to these people there in this specific context. But fourthly, as I explained in our model, it's reference with the legislation in that area where it is possible, explain why there isn't a significant principle infringement there. Cool, 2 arguments there. My first argument will explain why these people in these places have better quality of rulings and better quality of justice. The first thing I'll explain, and this is crucial, is that these courts are far less prone to corruption. Because especially in small South Pacific islands, corruption is a rampant issue. People are able to pay out magistrates and judges, and this is terrible. It means that companies are able to run afoot with no mechanism keeping them in check, causing heaps of environmental devastation in these places, and it does not happen. Why are these courts far less corruption? 4 reasons. Firstly, because these courts are larger and they're making decisions of far more noteworthiness, they have far more scrutiny put on them by all the signatories of all these different places. Second of all, we also modeled in rigorous pre-selection hearings. And I'm going to be honest, a lot of these countries just do not have this. They do not have sufficient corruption hearings from the get-go because legislators in these countries have no incentive to create corruption legislation to keep an accountability, to keep to account courts that they want to win over to make rulings favorable for them and their company buddies. Now I love you either. But thirdly, I think that there's far more likely to exist recourse because it's harder to win over every single actor. Because when there are more people in power, you need to pay more money and more bribes to win over them in the first place. But fourthly, I would say there is no, that doesn't make sense. So all of that explains why these courts are far less prone to corruption. And this is crucial. One corrupt judge on a legislature can, with legal wizardry, hoodwink other judges into making claims that are not good for them. This is terrible. We should not allow to do them. We make these courts far more immune to corruption. That is incredibly important and debate-winning. Secondly, what I don't know is that now second mechanism, you're far more likely to get poolings of resources for law reforms and commissions. Because the way that law reforms happen in many places is that countries pool resources or pay money to fund a commission legislation or a law review panel that publishes reports that courts then account in their readings. Like they refer to as tertiary legislation and say it's for the X and XY reason drawn out in this law reform commission. These have impact. You're far more able to pool resources when there's many countries doing this from the get-go. Thirdly, the quality of these judges are far better for two reasons. Firstly, the expertise of these judges go up because there's a greater pool. So if we're going to add this to the model, this is the last thing, but we have also allowed these courts, if they wanted to put forward judges from other, from like other places, like if they're a citizen and have gone over to the UK, lived there for a couple of years, it's like we would allow them to come here anyways. So you're allowing to draw them for far more places, the expertise judges going up. But second of all, they aren't out for political gain or ambitions because of rigorously model that out. Obviously, side negative might do model bashing, but we have more than enough yet to comprehensively model this out of the debate. Quality of justice is important, and I would weigh over access to justice because of the claim that access to justice oftentimes, like if these cases are very noteworthy, you can have fundraisers for pooling or equity exemptions where the court discharges some of the legal costs of these cases if they are of significant public standing. Whereas quality of rulings is something that is incredibly important inside Affirmative gets. Argument 2, you get greater access to justice. Why is it true? Firstly, the costs for legal counsel go down because now you can not only access law firms in your country, but other countries too, which increases competition amongst different providers of legal claims, which explains why the cost of law counseling and people goes down there. Second of all, it creates an impetus for funding because now when you have greater impetus for funding these courts, because now when it's like one court that's hearing very important decisions that affects many different countries, you get far more impetus for funding. And this looks like things such as attorney offices or district offices or stuff like websites and videos that explain these courts and their processes to other people. Thirdly, buy-in to the justice system increases for a number of reasons. Firstly, because they're hearing more important cases, that means that people feel like these cases are more important. And note that obviously, it doesn't matter if the local courts are more powerful. If people generally see the justice system as having more buy-in, being more crucial, they go to the courts in the first place. And that is incredibly important. We will extend on that at second affirmative.
Thank you for the first affirmative. I'll now call off the first negative to begin that case.
In this speech, I'm going to explain why negative team preserves national sovereignty, why we're more efficient, why we get better representation, and why we decrease, and why on our side you get less corruption and less political disruption. First, 3 things in setup. First, quickly on our model and their model. Two things to note about the motion. First, it's unclear, as was query to the affirmative team, how many judges are on the court. This is very unclear. This is very important. I'll touch on why in my efficiency point. Second, this is an appeals court. Contrary to what the affirmative team tells you, this is an appeals court, it only hears appeals. Quickly, our count, we just counter model, we were just doing legal nation building, so we just sent in some UN representatives and some legal experts to help do things like decrease corruption, help decrease foreign interference. We would just like counter model, we would just protect these countries, like we would just use the left the act to just protect these countries' legal systems at the domestic level. Second, then, on setup, why do appeals occur? When do appeals occur? 4 things under this. First, it's serious questions of the law, right? It's there is an unresolved question that could have significant ongoing issues for precedent. Second, it's for major crimes, so cases where people might be going to jail for a long time, really divisive cases. Third, it's for really major social issues. But fourth, finally, just tell you, it's like anything if the courts let you, right? Like if anything if the court decides, okay, fair enough, and that is much easier to do if you have lots of money, right? Finally, third, on setup, how does precedent interact with this, right? Because we know that if this court is going to be legitimate, it has to be binding on the nations that are under it. The affirmative kind of concedes this, right? That means you have a trickle-down precedent effect. Every decision has to be fully binding on every nation. We know here, this is kind of confusing, given, this is a little bit confusing, given they say that, oh, like the courts will all decide, like, decisions relative to the nation that is bringing it, so like courts will apply domestic law, but obviously, common law doesn't work like that, right? Like there are aspects of the law that are like just not, like there are aspects of the law that do have to be decided, that have to be applied, and it's unclear what the relative benefit of this court is, it's unclear what the benefit is if it is only applying on domestic nations. That's very unclear. Okay, moving on. First on sovereignty, right? That gives you really three reasons why this doesn't violate national sovereignty. I'm going to respond to each of these. First, I said there's like persuasive precedent, right? Countries can adopt bits of other countries' legal systems. Yeah, they can. In this scenario, you have to, right? Countries make decisions to adopt it. They don't have to adopt it, right? All of this case, they cited what the cases where countries chose to follow other legal reasoning. They didn't have to. Second, they say that it's a balancing measure, right? The judiciary doesn't matter that much because it's technocratic, it's a balancing measure. This just doesn't make sense. Yeah, it's technocratic, but you still want it to be domestic. You still don't want foreign interference in your judiciary. That's still really bad. It's unclear why that negates the harm of violating national sovereignty. Third, they just cite a bunch of treaties. Again, treaties are not binding. Countries can make decisions to not follow them. Treaties are not binding in the same way a court is, right? Okay, moving on. Okay. The argument here is very, very clear. In the status quo, countries make choices. They can have their own court, or they can cede their sovereignty to another nation. Note here, we can just use our capital to prevent those kinds of coercion. You can make it easier to set up your own court if you want to, right? Countries can just make their own choices. We saw that in the comparative, they hugely guided sovereignty, right? They take an entire branch of government and make it subject to an enormous amount of, and make it subject to something that is not domestic. They make it multinational. This sets precedent for a nation, right? This interpretation of law determines the application of law. This is an enormous sacrifice of your sovereignty to a multinational body. Just principally, this is bad, right? You know, this is particularly impactful in a lot of these Pacific nations because they're trying to decolonize right now. Like they're actually trying to assert their national sovereignty. They're trying to build a body of law that they might not have had for a very long time. That's particularly impactful on these countries. Second, on efficiency. Let's be very clear here. Delayed justice is no justice. If this takes longer, this is an enormous harm and you should weigh this very highly in debate. Very quickly, I'm going to touch on law reform here. And then points about law reform. It's super unclear why this happens. Again, if all the cases apply domestic law to that specific case, and it's just an international body doing it, it's unclear why there is any incentive for the nation, for these collected nations to fund law reform into a specific country's legislation. That's really unclear. It's just unclear why this would happen, right? To be clear, right, under the affirmative as well, there is one court for all of the appeals. Under our side, we have 15 courts. So we can get through 15 amounts of stuff in that time, right? We tell you, right? Note here, that if they decide, oh, we'll keep the same amount of judges exactly, that's really bad because you want the kinds of consistency that you get by having a very small panel of judges, right? Note here that they cannot just claim, we will keep the same amount of judges and we will just make it into an international body. First of all, super unclear what the benefit of that is. But second, we just tell you that makes it the way that lawless much less applied, it makes it easier to do corruption because you just pick and choose the judges you get. That's really bad. Okay, probably 4 legal reasons why this is particularly bad. First, this makes deliberation 15 times as long, it makes deliberation much longer. Second, judges have to be rebriefed more. Third, if a judge gets sick, or leaves, or dies, you have to restart the case. Note here, that's bad because this applies to more cases because you have fewer judges. That's a really big harm. Fourth, also note here, under their model, they say that you have to judge on you're applying domestic law. Note here that means that each judge has to be an expert in 15 different countries' laws. That's a really, really, really huge burden. To have expert level knowledge. Again, judges are expected to be very, very highly qualified, right? But you probably end up losing a bunch of credibility in the legal system. But to get even any level of credibility for that reason is an enormous, intense amount of effort. And we tell you, additionally, note here, there's also a huge amount of subtle differences. For example, common versus civil law. Again, very, very hard to do. And we tell you at the end of this is that there are a lot of cases that you need to get through, and time is really important, right? It is important for countries that are trying to develop new laws to be able to apply them. It's important because evidence decays over time. If you're in an appeal based on evidence, and witnesses are like dying or forgetting things, that's really, really harmful. That is because people suffer, right? Every time, the longer it takes to get a court case settled, the longer victims have to go without justice. The longer people send in jail if they can't afford bail. That's really, really harmful. It's in a way that's very highly debated. Third, representativeness. First, some countries will have more power. You have to take a trade-off, right? Either everyone gets equal, each country gets note that there is just a trade-off, right? That actually, right? Note that there is just an inherent trade-off, right? If everyone is equal, it's unfair to countries with greater population. If everyone has equal say, unfair to countries with a greater population who have greater stakes who will be submitting more cases. If small countries have less of a say, that's really unfair to them because they're probably the most vulnerable stakeholders, right? On some level, this is really bad. Also, they say that you can get people from overseas. I would point out, this is really, really bad, right? It's really, really bad if you have a panel that is half white men judging a bunch of countries in the Pacific. That probably is bad on optics, probably means you get worse judging outcomes. Second though, also you probably just get less women, right? That's just because if you're sending your best judge, if you're nominating your best judge, that tends to just be men. There's structural reasons why that tends to be men. So if you just have more judges, and you're not just nominating your one best judge from your country, you probably just get more women. I think this is important because we think representation matters, right? Especially in the legal system. It matters a lot. Okay, finally, on corruption and politics. Why is corruption more likely, right? They give 3 reasons why corruption is better, why they get less corruption. First, it's that you get more scrutiny. We tell you no, right? We don't think the court gets more scrutiny, we think it gets less scrutiny, because it's probably going to be embroiled in a bunch of other scandals based on all the things we told you about I told you about every other argument, right? It's probably going to be really controversial because of diversity. It's probably going to be avoiding a lot of political turmoil. It's probably going to look really bad. It's probably going to be a lot of other reasons why the court is actually probably likely to receive less scrutiny that are probably going to distract from the actual case being heard. Second, they talk about pre-selection. Again, we can just count them all in that we would have anti-corruption measures. Finally, tell you that there's, sorry, I'm just going to move on very quickly. We just tell you that there's less corruption because on our side, because on their side, you just have fewer people to bribe. You have fewer, if you want to bribe you have to bribe 7 judges to make one decision. That's like to bribe an enormous number of judges to make 15 separate decisions. That's really harmful. Secondly, so that countries often operate that there is an enormous issue with countries just operating in bad faith. People have huge incentives to nominate judges that might claim to do something when they're initially being pre-selected, but they operate in bad faith. You just get worse corruption, you get worse foreign interference. People get crowds to them.
Thank you very much for the first negative speech. I'll now call up the second affirmative speaker to continue their case.
Whoa.
Four things in the speech. First, on corruption. Second, on sovereignty. Third, on pooling resources together. And fourth, on certainty. Let's first start on corruption, because I think this is the easiest way for us to win the debate. Because I think if justice is not served, if it is corrupted, which means all the sovereignty arguments don't matter if the justice is corrupted in the debate, and none of that falls through. Because you can have your own sovereignty corrupted. The Solomon Islands can have their sovereignty of their decisions corrupted by China infiltrating and persuading certain justices to do certain things. So we're able to claim that you get, let's stop shaking your head, Tom. We're able to persuade you get better corruption, less corruption on our side. We are able to persuade this. Our explanation for this was pretty simple. It was that there was more oversight in this court. If you believe that one of the justices was corrupt, they all held each other accountable in different ways. If one was persuaded by China, the other ones were able to be persuaded by other people and held each other accountable. But there just was more media scrutiny on this national court. The same way I say there's more media scrutiny on cases like the ICC than there is on the Solomon Islands National Court, just because it affects more people, there's more incentive to hold them accountable. I think we're able to explain it in those ways. But I don't think we also explain we get a better selection process. Maybe we get 9 good justices from NIU, we get the 9 best justices from the Pacific Islands together, we have a broader people to pull from, therefore we get better selection processes. We also say that it's harder to corrupt one court with many justices on it, and in many cases they have one court with one justice on it, or even if there are many, they know each other very well and worked for a long time. We have the anti-corruption measures that we're able to explain to you. I think the impacts of our corruption material was we got things like buy-in to the court, people were able to fulfill things like sovereignty and upside. They say that they can counter more anti-corruption measures. I think it's a different set of people that are doing the they're going and doing the anti-corruption in these countries. I think I'm unclear what it looks like. But also, like, I don't know what the anti-corruption measures that you are counting look like. It like just sounds like modeling out corruption, which I don't think you guys can do. Like, you need specific measures in the ways we're doing it, rather than just saying we would stop corruption. They say they can do things like nation building. Again, I'm unclear that they give a direct mechanism as to how they're going to do this. This also sounds like it's going to concede the sovereignty argument. Because what is corruption? What does that look like? Apparently it's being decided by UN officials, who are probably the same white men going and deciding what corruption looks like, and they get to fill that. I think this corruption argument is able to weigh pretty easily over their sovereignty material, because as soon as it's corrupt, sovereignty doesn't matter, because people don't get to actualize how their court works. That's the only reason we care about sovereignty, reflecting the will of the people in those states, and if it's corrupted against them, then we don't care about sovereignty anymore, because it is affecting them. Let's next go on their sovereignty material. They say that you're able to get sovereignty because every case is binding on every country. I think that we explained and modeled pretty clearly that that's not going to be how it works. A case about the Solomon Islands is binding on the Solomon Islands. A case about NIU is binding on NIU. A case about Tonga is binding on Tonga. That made relative sense. I don't think this team is able to prove that it does work in the other way. Just other responses to this sovereignty material. I think this team loses a bunch of sovereignty as explained into a slide. They go to places like England, they go to other places, and they forfeit in those ways. I don't think that they're able to claim their sovereignty material to the basic extent that they're able to explain. They say that overseas justice is bad, you guys do more of them, but they're better on our side because we get to pick the ones. So if a certain country, like Fiji, wants to nominate a justice that is from a different country, they get to do that, and that's an action of their sovereignty. So our sovereignty material is still able to stand because countries get to pick. I think that their material doesn't make sense, because to leave their case, you have to withdraw from any binding institution, even if you believe our stuff is binding. You would withdraw from places like the WHO, you withdraw from any international organization which can have any capacity over you, because that would mean people can be sovereignty. I think we'll say all these nations are already members of all these institutions, they're members of the UN, they're members of the WTO, and they're impacted in bad ways sometimes by them, but clearly they will have a real preference to trade off their sovereignty for other things. I think they're able to do it in this way as well. The sovereignty material is out of this way. Let's next go on to the stuff that we explained about pooling resources together, how to us and better. I think this is important because we explained we're able to get more justice and better quality justice. This team may get thousands of cases through. We said they're not very good cases because we get the wrong justices picking them. Our explanation for this is pretty simple. It was we bring your best justice together. You get the better quality ones, it's prestigious, being an international one, organized by a bunch of different nations together. You probably want to work there as opposed to wanting to work at some domestic court of some nation that most people probably haven't really heard of that much. You're able to do things like saving money, which means you can get more cases through, or just saving money for these nations that both teams explain support. Probably a benefit in the survey that we're able to accrue to them. But I think we also get more people being able to access justice when it is cheaper because you pool the resources together. What did they say on this? They said they can get through more cases on their side. Unfortunately, because the material explained first negative, it doesn't really matter how many cases you get through. The more precedent that we develop gets through. So we get one case through, and that sets a precedent for how the domestic courts operate. We are able to claim that benefit. So the question will be, how good is that precedent? We get better quality judges deciding that precedent, which makes it really easy for most of the judges who don't have the best and most technical understanding of how the cases work. They're able to repeat and use parts of judgments from really qualified judges that explain it in ways that make sense to them, and they're able to use it in that path. They say that judges need to be expertise on a bunch of different laws, and that is really confusing. 4 responses. Firstly, I truly say it's true for any federal judge, sometimes governs on things like state laws that are appealed to a federal court, and they're able to do it, they're able to decide, understand, interpret the New South Wales law when it's appealed to them. Secondly, I would just posit that these countries have similar versions of law, because they come from similar contexts, they've been formed by similar parts of colonialism, maybe their cultures aren't exactly the same, they probably have similar way of thinking by being in similar circumstances that form their ideas. I don't think there's any reason to believe that they have ultimately different ways, and even if they do, it's like probably 2 different ways, and we can probably learn both of them. I think thirdly, is this might actually be a benefit. You have to investigate the law more, rather than being convinced about how you learned it in university and what your lecturer told you and the ways you formed your biases. But you get people who aren't biased by their previous interactions with the law, and on our side are able to flip this because they look at it with fresh eyes and they're able to understand it better. That is able to flip the material that they give you. But fourthly, I would say that we have one justice for that nation, and that justice can probably explain to you how it works in ways that just make sense. And that means you're still able to get the sovereignty because you get the interpretation from the person from that country who understands the best expert in the country, the one who just does happen, who was selected for being the best at this. You probably pick your justice who was the best to explain the way the rule of law worked to other people in ways able to work. Also, if this thing's not true, we probably get other experts in to come help us. But we have the best experts on our side, it's unique benefit we're able to get. Let's do the weighing on the argument of pooling resources, because something our side uniquely does when they spread theirs out across a bunch of different things. And it's because I believe you don't end up having good justice. You don't end up having good justice is more important than having a really quick but bad justice on their side, because we're able to get that. We get the domestic courts to follow the precedent of the good courts, and that means we're able to claim all their benefits by getting the people who have less expertise to follow the good expertise and do it well. The last way we're able to win this debate is that we get more certainty in court hearings. The reasons for this are twofold. Firstly, because of the things we explained about being internationally watched, means you're less likely to change the way you're doing it because there's the same level of accountability all the time, the same pressures following you as an international court, rather than changing domestically according to domestic political changes. But secondly, even if you believe that like some nation changes, like the Solomon Islands elects a new government, I think that they counterbalance each other because one nation changes but the other 10 or 11 stay the same. And that means there's more consistency in the way the court determines. Because if one of them shifts one of their justices in just the domestic court and someone else branch stacks with all the justices they like, that is really impactful because it changes all the precedent in the way it works. It means there's no certainty in decisions. When you're opening a business, you're not sure that you're going to be able to get the benefit because the court decision won't be the same a year later because they might get someone else in. On our side, you have more certainty. That means you get more things like foreign investment because you're certain in the way that businesses are going to be regulated. That brings jobs and prosperity to people in these nations. It has an impact on more people than just a few people. The court cases are affected by. But the vast majority of people have substantial impacts. Justice was discursive, but things like being able to get investment were incredibly important. But also things like when you do crimes, you need to be able to know that what you're doing is going to be a crime, be certain about your actions being able to be safe. And that means that people are more certain on our side that they aren't going to be hurt and sent to prison for things that they didn't think were crimes, with more consistency in the justice. Look, at the end of this debate, I think our team wins on a few things. First, I don't think this team proves that their sovereignty material is distinct from any other way that sovereignty occurs in the debate in other ways. But I think things like pooling resources mean that they will get better quality justice and quality matter more than quantity. No explanation from that team is for that. But I think things like not being able to corrupt, because we have international bodies holding you accountable, everyone is watching you. And even if you didn't believe that, at the end of the debate, you must believe that our side is able to get certainty and justice that had a bunch of benefits that supersede and were extraneous to the rest of the debate. For these reasons, proud to affirm.
Four things we teach. The first question I'm going to ask is about the question of certainty that Will gives you quite comprehensively and Bennett does not respond to. I'll explain why I clearly went to the debate. Firstly, because we told you that the catalysis changes within the domestic court system, in which things like political scandals or corruption scandals mean that justice might change, means that there's a lot of uncertainty about the law. And I know that this uncertainty is quite prevalent in the country. It means that businesses don't know how to set up businesses, they don't know the regulatory framework of the tax laws, for example, to do business. And that is quite prevalent. And this isn't just the vague sovereignty harms or the corruption harms that this team points to. It is stuff like less economic activity. It is people being unemployed because businesses are less economically fruitful. And secondly, we told you that it's internationally watched, which means that there is increased certainty to the court hearings. And I know uncertainty, it is unclear whether the sovereignty of these courts or the corruption of these courts meaningfully changes on either side, but we can ensure that the certainty that these people feel when there is a transnational court definitely does happen on that grounds alone to win this debate. Three other questions. The first question I'm going to ask is about the integrity of justice. Here I'll deal with the questions of corruption and sovereignty. Firstly, on corruption, we tell you that these judges are far less prone to corruption for a couple of reasons. Firstly, they say that scrutiny is spent. Firstly, they say there are fewer people to corrupt on our side, but obviously this isn't true. There was the same number of justices on the National High Court of Appeal compared to the Transnational High Court of Appeal, like 9 people or whatever, still corrupt the same amount of people. But the difference was that in our world, these justices were likely paid more because like richer countries could probably subsidize and fund these courts more, which meant that these justices, because they were prestigious or whatever, were probably paid more, which meant that they were less prone and susceptible to corruption. The next point they give is that people only pay attention when the transnational court is ruling on your jurisdiction. Yes, this explains why there are multiple sources of scrutiny from different countries when it comes to these courts. And I'll also note that they're probably also dealing with transnational matters, so obviously there are multiple sources of scrutiny at the same time. This explains why, at whatever point, there is at least one source of scrutiny there, and diverse sources of scrutiny is obviously good because it means that we don't get like partisan grounds, whatever. Secondly, they say there is a short-term limit. Like, firstly, 9 years is a pretty long time. You can investigate them for corruption. But also on their side, if judges are corrupt, and I think their side, they're saying that they support like lifelong judges, like that corruption is entrenched, right? Like they're fucked, right? That corruption is like entrenched forever. 9 years is a pretty good idea. Thirdly, they say they're completely incompetent. But I think this is obviously untrue. Obviously, there are so many sources of scrutiny. There are so many legal experts out there that can like put bullshit on their plea to incompetence, right? Then they say that pulling out corruption now becomes conflated to a political issue. Firstly, the media already does that. The media does this most of the time. Therefore, it's not political. And secondly, even if it's not the media, it's things like independent law reviews or journals, which obviously aren't connected to institutions. But secondly, if you believe Bennett that countries will have current disputes, have current disputes, this means that they'll call out other countries they're seen as to be corrupt or influencing them. Thirdly, it's far more political on their side, where they're appointed by political parties as opposed to independent judiciaries under our side. But fourthly, yeah, corruption often is political, and we call that out. You should call out nations for bribing each other. That was a good thing. Their reliance is to say, like their Hail Mary, to say, oh, we're going to counter-model out corruption by doing pre-selection measures. Firstly, I think if it is a national pre-selection measure, it is far easier to corrupt for the reason that it is like the levers of power and the corrupt institutions are close together, right? But if it's international, everyone is trying to keep each other accountable, right? There are lattices of accountability that mean that corruption likely won't spread. But secondly, I just doubt that this team has the capacity to impose the very stringent pre-selection measures, because as I know, many nations are just poor. They lack the funding for judiciaries, they lack the funding for courts. Under our side, richer states and richer Pacific nations can ensure and subsidize this kind of pre-selection model that we exclusively get because we pool resources together, a mechanism that still has remained unresponded in this team's case. So, at the end of this, you should believe a couple of things. Firstly, sovereignty was not an issue they could win on, and secondly, corruption was a clear win to us. It meant that the quality of judgments got far, far better. Okay, the next question I'm going to ask is about the quality of judgments that arise from this transnational court. Their big challenge is to say that, oh, there are more than 7 competent justices in these countries, that's fine. Firstly, on comparative, our point was to say that we get the justices that are the best, right, out of all these countries. Obviously, those, like, maybe there are 7 competent justices in each country on your side, but we get the best out of all the countries, deciding on very important, very precedent-setting matters. That was an uncomparative claim. But secondly, I just know that there is a really large imperative for this, right? Because I know that in these very small Pacific Island countries, there just does not exist much legal expertise. Firstly, because they're very small populations. Secondly, because they're often poorer, and they often can't, often people do things like study agriculture or irrigation as opposed to law. Thirdly, because there often existing a form of brain drain where these justices work in overseas courts like Hong Kong or Australia, which means that these countries uniquely need the skill and expertise that our side gives you. The next challenge is to say that the legal systems are different, and this means that the quality of judgments are far poorer. But obviously, this was a very uncharitable reading of this motion, because you don't need to know the laws of 15 countries to decide and interpret them. You just need to know how to apply them. You need the legal training and the expertise to know how to read legislation, to know how to apply it, to apply reasoning to the law, which is still a very rare skill. For example, there are 100 laws that are made every year in Australia. The judges obviously don't spend the time memorizing and learning off by heart those 100 laws. They just have the base skills to interpret and read them and apply them in the judgment as necessary. This was a ludicrous claim. This should not win the debate. But why else in quality of judges got better? Because we just had more access to an international market of judges, which were attracted by this very high prestige court, right? Because if it was the South Pacific, not a transnational court, obviously you got a flock of foreign judges coming to this court, which brought their expertise, which brought their legal skills. They say it's colonialist. I really don't think it is. I looked at the Hong Kong Court of Appeals, pretty competent judges that aren't deciding on matters of sovereignty, but are deciding on matters like tax or corporate finance. I'm not prejudicing, guys, but trust me on this one. Yeah. Okay. So on the quality of judges, we clearly got more qualified judges. We clearly got more experienced judges that had years and years and a lot more legal training than the judges that these guys could provide. The last question I'm going to ask is about the efficiency and the access to justice. On our, basically, their claim is that on the side negative, there are 15 courts, whereas on our side there's only 1, so deliberations take longer. But firstly, these countries are pretty small. There's 16 million people total. The UK has 100 million people. There's 1 court of appeal in the UK, and they can service that many people. Unclear as to why this point is even true. But secondly, obviously we keep the national courts of appeal, and the cases that this transnational court hears are those that are very serious, are those that have appealed from the national court of appeal to the transnational court of appeal. That's to say, there's a better prioritization and segmentation of cases, which increase increases allocative efficiency, right? Because it doesn't mean that national courts of appeals are bogged down hearing all the national courts. They can prioritize the ones they can hear and then defer the ones they can't to this transnational one. But secondly, as Will explains to no response, better quality judgments and better quality precedents increase the efficiency of these courts, right? Because it meant that instead of having to go through the arduous court process every time, they could rely on well-written judgments, etc. We also gave you a bunch of reasons as to why there was greater access to judges. Firstly, because the cost of law counseling went down. Secondly, because there was increased entitlement for funding. And I know that on our side, because richer countries could subsidize and fund these transnational courts, this increased efficiency, right? Because now the transnational court had more resources under our side as opposed to their side, which is marred by inequality and geographic, disadvantage as opposed to that. The third reason we gave is that we increased buy-in into the legal system because firstly, courts just did more important stuff and they probably had better quality judgments that people could trust more. But secondly, because now they were seen as less corrupt and more trustworthy because there were these lattices, these lattice systems of accountability that we explained to you, which means it is very important. This point is very important because it now meant that people trust the judiciary, it meant that people went to courts in the first place, it meant that they funded courts in the legal system, so increased political capital to do that. For all those reasons proposed.
Thank you very much for the third affirmative speaker. I'll now welcome up the third negative speaker to continue their next.
Firstly, got to deal with corruption because the only way the side affirmative attempts to win this debate. Firstly, they claim that third affirmative stage, you have the same level of people who bribe, and therefore corruption is likely to be symmetric. We pointed out that this obviously isn't true. You have way more people to bribe. It's far more efficient to bribe someone under their side, whereas you have to bribe a whole series of people under our side of the house. Obviously, there's far more accountability in those mechanisms there. The second claim that they make, that richer countries are likely to subsidize, and therefore you get less corruption, because now all judges are paid more on their side. The first problem I would point out here is that you have no incentive as Fiji to pay for the judges of countries, who are poorer. That makes no sense. But I would say that even if you do believe that claim, this does not decrease the disincentive to be corrupt. Because if you are likely to be a corrupt judge under their side, you are likely to be a corrupt judge for $100, $1,000, $10,000, or whatever the amount is, because you deeply believe that you are an egomaniac and you can get away with it no matter what. You do not care about the rule of law. There is no change from the incentive of countries. There is no change in the incentive from judges. Nothing changed there. The third claim that they try to make is that there are multiple sources of scrutiny under their side because there's a whole bunch of countries watching decisions. We preempted this and explained that this is obviously symmetric. Because you only watch decisions that are relevant to your own country, it is not clear that you have any increased disincentive there. The fourth claim that they then try to make is that you have independent appointments, which are really good, which is in comparison to politicized appointments that exist under our side. We point out that obviously politicized appointments are far more likely under their side, because you're choosing a judge to be your representative at a huge high council of huge beings, which is going to decide under their side, in order to access any of their benefits, the decision needs to be important, large, and huge, which means there is a maximal incentive under their side to put the most political decision possible, to make the most politicized judge to be on the council, to be on that bar there. Obviously, there is a far greater incentive to be politicised on their side. The fifth claim that they then make is that the best judges are collated, and that therefore they're likely to make the best decisions as a result. Bennett points out, albeit somewhat poorly explained, that there are two separate systems that are likely to be a part of these countries. You have the French system, which he tried to explain as inquisitorial, and the English system, which he tried to explain as adversarial. These are the antithesis of one another. Maybe you are an expert in one of these two systems, but you do not have an automatic skill carryover. The only explanation that Michael gives is that you are good at reading, and therefore you will be good at all systems. But obviously this isn't true. You are trained and specialized over your career to be the best at your job. The simple intuition part I will give here is that you are, like the ICC doesn't deal with every issue that exists. We don't have a giant world court because you can't have a judge that knows every single possible issue that could ever possibly exist. You have judges that specialize, who have developed law themselves, which is why they're experts in it, who know what those outcomes are there, who understand how these cases go. We've seen 100 of them go before them. They're obviously only experts in specific things. There is a great vast variety of things under their side. But finally, even if you believe that the inquisitorial and adversarial system are exactly the same, obviously these countries change them in their host nations over time, which is why the Australian system is not the same as the English system. It's actually a Frankenstein system of a whole bunch of other systems, which means that you actually still need to be specialized in your own country's legal system. You can't just rely on somewhat similar systems, because those differences matter. Things like mandatory minimum sentences do not exist in a lot of Westminster systems, but they are hugely important in sentencing in Australian systems. So you simply cannot have a skill carryover there. The next claim that they make is that some countries are really poor, and therefore they have bad judges. This is incredibly offensive to these countries. Bennett points out, you literally need a handful of these judges in order to make these decisions on the outside. I think it's wildly patronizing to say that Kiribati and these other countries do not have judges who are able to do this. But I would suggest, for a bunch of structural reasons, why this is likely to be the case. Three. First of which, you have wealthy people in these countries who are likely to ensure and want to have people who are good legal experts, you have good legal decisions that are made there. But secondly, you have patriots. You have people who care a lot about their host country. So when they talk about brain drain, we think it's quite likely that maybe after you've made your money, you have a passion for your own country, come back home to your own country, and you want to build that legal system. But thirdly, I want to point out that a lot of judges are actually massive egoists. When you have primitive, nascent legal systems, they see an opportunity to develop that legal system, to make it better, to make it cooler, to actually have a legal system that's kind of specific to their own country. They see and have seen, like, in their own country, the issues that existed in their own legal system, and they have a unique opportunity to change it, and a desire to change it, because it is their own country. Not that these people don't exist. But finally, legal systems obviously function in these countries currently. Like, it's not as if these countries are all just anarchists. Obviously, we do have legal systems, and maybe they're not paid as highly as some of the other legal systems in the world, but that does not mean that they are bad. 7, they say that these legal systems are mostly, oh wait, I've responded to that already, my bad. The final claim that they make is that, oh wait, I've responded to that too. I'm doing so well, this is awesome. Okay, so at the end of this, obviously corruption is substantially more likely to occur under their side. Obviously, these systems are far better at handling these issues domestically, but crucially, you are only an expert in your own country's legal system. It is wildly unclear to me that you can educate a whole room of people of a random number, they never gave us a number of how many of these judges are on a panel. I'm going to assume charitably it's 9 judges on a panel. We have 15 countries, so I guess some people just miss out. Fair enough. As a result of that, that's incredibly problematic. I would question that actually quite a bit. That's a very weird mechanism. Okay, cool. Secondly, let's deal with sovereignty. They say this is not a way that we can win this debate. We give you 3 pushes. The first of which is that you need to self-govern because sovereignty is important, because it's important not to have external influences. The second thing that we explain, this is especially important for nascent legal systems, which have a greater capacity to develop because every legal system, every legal decision matters disproportionately more in a country that has less legal decisions, you have less landmark cases, you have less bright line judgments, and you do not have things that you can rely on there. Every decision is far more important there. The final thing that we make is that other countries are literally governing you. You have decisions made by judges in Tonga and Samoa, not Somalia. I did that incorrect as well. That are incredibly important because they're now making decisions for countries that aren't their own. It's not clear that that sovereignty is not eroded. They give 2 broad responses. The first of which is that certain countries already outsource this in the status quo. I would say at the absolute best case, this is just mitigation because not all countries do. Some countries do obviously have their own full domestic appeal system. But secondly, I would point out that even if they all are, this is a far, far more preferable system for 2 reasons. The The first of which is that the UK Privy Council has far better trained judges, purely for the purposes that they have more resources, they have higher education systems. But secondly, I would point out that they're under far more scrutiny because your host nation is always having the same decision from the same group of people. So you're not just tuning in when a decision affects you, you're tuning into every decision because every decision affects your own nation. So you have far, far more scrutiny that exists there. Sovereignty does not erode as easily. The second and better claim that they make is this only binding on nations that exist in question. But I would suggest this is simply negation. Obviously, whatever nation that exists there has some form of sovereignty that is eroded. But secondly, this is the worst sort of binding because this is done by a whole series of other nations who are not even experts in your own system. This is wildly confusing. At the end of this, obviously sovereignty is eroded. Maybe there are some countries who have not as much sovereignty as eroded. That doesn't mean that no sovereignty is eroded. And I would suggest that sovereignty is incredibly, incredibly important, particularly as you point out that disproportionately these decisions affect the legal systems formatively of these nations. Finally, let's deal with efficiency. They make two claims here. The first of which is that the UK is big and they can handle a whole lot of decisions. Two responses to this. First of which is that, yes, the UK has far more resources than the rest of these countries, so it's obviously not clear that they can handle it to the same extent on the side of Affirmative vote. But secondly, the UK Supreme and appeal systems have wild backlogs, multiple years worth of backlogs in order to get your cases decided. This is a massive issue. Yes, when you pull a whole bunch of people together that have a whole bunch of legal questions and have one resource that has to answer it, it does just take more time because you're not doing it as efficiently. But secondly, they try to point out that this is only important. Only the most important cases get pushed through. We preempt this and say this is a resource issue. Even still, these cases take longer. But secondly, we point out that lots of cases are important to these legal systems because they are nascent, which means that you do need expediency on all decisions that are made. Please slide negative.
Thank you very much for that debate.